So, hello everyone. My name is Spencer Hawkswell. I am the CEO at TheraPsil. I'm a patient rights advocate and lobbyist, and our organization TheraPsil, too, is a patient rights advocacy organization and coalition that aims to help Canadian patients and healthcare practitioners access legal psilocybin through medical regulations. Our organization is founded upon the four pillars of advocacy, research, public education, and professional training. Today I'm here with lawyer Nicholas Pope to discuss his role in advocating and legal work in helping patients and healthcare practitioners access psilocybin. So without further ado, Nicholas, I'll put it over to you to introduce yourself, a bit about the work that you do and are doing with TheraPsil.
Hi, I'm Nicholas Pope. I'm a lawyer at Hamid Law in Ottawa, and we do human rights litigation. I focus mostly on administrative law, which is the area of law of review of government decisions. So we ensure that government decisions are made in a way that is reasonable, procedurally fair, and follow the legislation such as the Canadian Charter of Rights and Freedoms. And that's where we come into these decisions around psilocybin, because these are often decisions made by ministers of the government or various bureaucrats. And so one of the ways that we can move things forward and increase access is by having the courts review these decisions that are made by the government departments.
Awesome. Thank you very much, Nicholas. Now, we've had a number of different patients and healthcare practitioners in Canada asking the government for access to psilocybin through Section 56 and the SAP process. For those listeners out there who don't know what these two processes are, Section 56 is essentially a piece of our Canadian Drugs and Controlled Substances regulations that says that any patient in Canada can ask the Minister of Health for access to any of the controlled substances out there, in this case, psilocybin. So indeed, it is individual patients requesting from the Minister of Health, our top health official, for an exemption so that they can go out there and use psilocybin. SAP is a different system. It's more used for patients who are trying to access, different drugs that are maybe not allowed in Canada, but are allowed elsewhere in the world. Many cancer patients and their doctors use the special access system to use drugs, experimental cancer drugs that aren't accessible. And that, as of January 1st, 2022, is the route that the government is pressuring many practitioners and patients to take. So back to some of these Section 56 and SAP requests that were denied from health officials. I was wondering if maybe you could take us through the case that you were leading, I guess it was last year, with one of the patients who was denied access to psilocybin through Section 56.
Yeah, so last year, we filed a case on behalf of Nathan Kroljak back in July of 2021. Now, Nathan, he was diagnosed with cancer around the age of 25 back in 2006. And along with that came a lot of psychological trauma. He was experiencing end-of-life distress and anxiety, and he tried a lot of treatments. He tried all sorts of traditional treatments from therapy, different medications, and none of them helped, or none of them sufficiently helped to alleviate his anxiety and all that came along with that. And so he applied with the help of TheraPsil back in March of 2021 for a Section 56 exemption to be allowed to try psilocybin-assisted psychotherapy. And he had support from a physician who said this would be a good approach for him to try. Now, he applied in March, and we were contacted by him sometime in June or July because it was about a bit over 100 days from the time that he applied, and he still hadn't gotten a response. Now, I should be clear, we're not saying he didn't get an approval, and that's not what we're challenging here. He didn't even get a yes or a no. He didn't get a response on his application. And to note, some decisions on Section 56 applications had been rendered within one single day in the past. So it's not like this is some process that takes some inordinate amount of time and it just takes months and months to get done. The government had managed to render these decisions within one day when it was needed. And so here we have Nathan, who's waited 100 days. And so we filed an application at federal court. And this was an application for a judicial review. And a judicial review is simply, as the word states, judicial, a judge, and reviewing the actions of the minister. And there are a number of different remedies you can request within that judicial review. In this case, the remedy we requested was something called mandamus. Now, that's just a Latin word. It means we command. And so in common language, we're requesting the court to command the minister to render a decision. Again, not specifically a yes, just any decision, a yes or a no, because that's their duty under the Controlled Drugs and Substances Act, is to make a decision. And so we filed the claim, or we filed the application at the federal court and waited and went through the process. There's a number of procedural steps, and those took us through the fall and the summer. And the government, well, a lot of the times with these sorts of applications, and we've done them in a various other contexts, whether it's immigration or prisoner transfer, and the government usually acknowledges that, yes, we do have the obligation to render a decision, and we'll usually negotiate and say, well, just give us a little more time, maybe give us 60 days, and then we'll render the decision. And then there doesn't need to be a court case around all of this. But none of that happened. The government just kept going with the court case, and we had to, they put forward an affiant, they put forward someone from Health Canada to speak to the reason why there was no decision. And we found out through that they had essentially frozen all the applications for people who they didn't consider to be terminal patients. So if they didn't consider them to be, for their death to be imminent, then they just were not making the decisions while they're doing some policy review, they said, in order to make these decisions in some more consistent manner. But because of that, everyone who's in a situation like Nathan, who didn't have a diagnosis that they're going to die in some short period of time, was simply left there to wait. Now, we took this all the way right up to almost a hearing. We made all of our written submissions, and we're all ready to go. Got a hearing date for early December. I believe it was December 8th. And then on December 6th, Nathan received an email saying that his exemption was granted just 2 days before the hearing. And so we, of course, abandoned the hearing date, and he received a positive decision. So that's great. But a huge amount of resources were spent, a lot of my time prepping for all of this and writing the arguments, and the government's time. And frankly, it was a large waste of resources, I think, for the government to make us go almost all the way to a hearing just to grant us what we wanted, when they could have just, I'm sure if they had told Nathan a few months earlier, hey, just give us an extra 90 days, we'll grant your exemption, then we could have avoided all of that process.
And that's very interesting, because it almost shows that, like, at some point you've got to force the government to make decisions that, if allowed at some level, they'll just, claim don't need to be made. It doesn't really seem fair to me that, the government be making a decision on, who's worthy of an exemption and who's not. Do you think there's any merit to that? Like, do you think that there was any wrongdoing of the government to say that just because someone is closer to death, that they may be more, deserving of a decision, while someone who's not dying, deserves to have their exemption frozen? What are your thoughts on that?
I would say, I don't know if it's wrongdoing in a sort of legal sense, but it definitely was, there's no real legal basis for it. When you submit an application, you have the right to have a decision rendered, and you have the right not to have it frozen any place. The law does say, it doesn't, this is just in general for government decisions. While it may take some time for the government to make decisions on whatever sort of application you've put forward, it's not excusable for it to sit at one stage of the process for a long time, just doing nothing. It's okay if it keeps moving forward because there's work that needs to be done on the application and various steps take various amounts of time. But if you just sit it on the shelf, regardless of what reason that is for, whether it's based on whether or not you consider them a terminal patient or not, or any other reason, you can't just let an application sit on the shelf frozen without doing any work on it.
Absolutely, and I guess it's good to acknowledge that the government must have or seems to have accepted that, because not only did they grant Nathan's application, but they also granted the applications for many other patients who were similarly waiting, and that was great. Now, I would also love you maybe to talk about the other exemptions that were requested from healthcare practitioners in the form of Section 56 exemptions, and then maybe what happened in that situation, because in that situation they were actually told no, or many of them were told no by the minister. Is that right?
Yeah, exactly. So the background to this is that generally in psychedelic therapy, it's accepted by experts that for the practitioner to provide the therapy, the practitioner should have had personal experience with the psychedelic, meaning if somebody's going to treat someone else with psilocybin-assisted psychotherapy, they must have experienced that altered state of consciousness themselves. Otherwise, it can lead to less safe treatment or less effective treatment because the one providing it doesn't really understand what the person they're caring for is going through. So that's well established in the scientific community. You'll be hard-pressed to find anyone at all in the field, any sort of researcher, any sort of practitioner who would disagree that that's the best practice for this. So because of that, back in 2019, a number of healthcare practitioners requested Section 56 exemptions so that they could undergo this experiential training and then be able to provide therapy to people. And the government granted that. The minister granted that to 19 of these healthcare practitioners in around winter of 2019-2020. And then after that, more healthcare practitioners made similar requests, over 100 of them. And this was because there's just not enough healthcare practitioners in Canada right now to meet the need. And they're isolated in certain parts of the country when we have a large country. And there's just not, if you're a patient needing access to psilocybin-assisted psychotherapy, it's very, very difficult to find someone who can assess you and treat you. So these practitioners submitted their requests over a period of time there, and many of them just sat and waited, much like Nathan did. Some of them waited even longer than he did, but of course they didn't bring any sort of applications for mandamus, presumably because there is, for them personally, it wasn't having as much of a profound effect. And what happened was on January 31st of this year, 2022, the government sent out a whole host of letters to many of these practitioners. These letters were notice of intent to refuse letters. And that was essentially saying that we are going to refuse your Section 56 request, but you have one last chance to give us some additional information to dissuade us from doing so. And they gave the practitioners 2 weeks to respond. And the reason that they provided for denying these requests was simply that they said there might be a possibility that you could get access to psilocybin through a clinical trial instead of through Section 56. So you don't need a Section 56. You might be able to do a clinical trial. And the basis for their belief in this was that just that very month, in January 2022, a clinical trial had been approved for healthy healthcare practitioners. And that's all they said. They didn't give any information about what this clinical trial was, how many people were allowed in it, who would be allowed in it. No information. And so we're left with that. And so I was retained to represent many of these healthcare practitioners, 82 of them at first, and then submit a response for them. Now, we contacted the government and asked, well, what is this clinical trial? What's going on? Tell us what it is so we can actually respond. And they didn't get back to us in time. And so we ended up getting an extra 2-week extension, so 4 weeks in total. And they gave a little bit of information to say it was this ATMA trial that was approved. And there was a little bit of information, but it was still lacking. So anyways, we made submissions in response to the notices of intent to refuse. And the submissions were fairly lengthy. There were something like 20 affidavits. Affidavits are simply written sworn testimony, so like a witness going on the stand in a courtroom, except on paper. So 20 of these affidavits from various people who know the area in Canada, from people like Dr. Valerie Masuda, who is one of the practitioners who was granted an exemption earlier and was able to attest to how important that was to her practice, as well as attest to how much work it is to treat someone with psilocybin-assisted psychotherapy. And so you actually need lots of practitioners. It's not good enough. She can't treat the need of all Canadians. As well as lots of data about the number of people seeking treatment, the need for experiential training, something in the realm of 20 scientific articles talking about the safety and efficacy of psilocybin-assisted psychotherapy, and the affidavits from 13 patients as well, people who stepped forward. We just put out a call and said, can people tell us about their experience? There were some people on TheraPsil's wait list, and some people volunteered to talk about themselves and their experience, and 13 people stepped forward and told us about their struggles, their various conditions, and how they've been unable to get treatment or find anyone who can assess them and treat them, and sort of the impact that's had on them. So all of this was submitted along with legal arguments to the government, and the main legal arguments were, there's essentially two issues. Number one, that their claim that this possible route of access through a clinical trial gives them reason to deny the exemptions just doesn't hold water, because one, the ATMA trial, we later found out, only had something like 20 spots and was probably reserved only for people in ATMA's program, so essentially inaccessible to any of these 82 people. And then there is some information from someone on the UBC Research Ethics Board who said it would be unethical to conduct a trial. So if one of these practitioners or TheraPsil was to try to conduct a trial, that actually wouldn't be ethical, because you can't conduct human experiments if you don't have a really good reason to do so. No matter how safe psilocybin is, you just don't put people through experimental trials unless there's a really good reason. And figuring out whether psilocybin is safe for healthy adults is not a good reason. We already know that. There's tons of trials out there that already tell us that. As well, and this is a big one, is just the amount of time and resources it would take. There were affiants who testified that it would take over a year just to get from an initial setup to the final place where a clinical trial would be ready to enroll participants. And that's just enroll participants. So a minimum a year. And then that delay means that the healthcare practitioners aren't trained for a year. It means they can't start treating patients for more than a year. And so you have people today, and many of our affiants of these patients who are suffering. Many of them suffer from suicidal ideation and have attempted suicide before. And so some may potentially die before they're able to get treatment, let alone all the others who just lose a year of their life to suffering, which you can't get back. You can't get back time. There's no amount of money that can give someone back one of the years of their life. And so we made all these submissions along with the second issue, which was that we said the government has to grant this exemption. There's no other reasons out there that could possibly make them be allowed to not grant the exemption, and that's because Section 7 of the Charter, the right to life, liberty, and the security of person, is engaged here because patients, their health is compromised because they can't have treatment because there's not enough people to treat them. And so because of that, and this is under good authority of a Supreme Court case, PHS, where the Supreme Court said just that. If there's a medical treatment or some medical access through Section 56, and there's evidence that it would improve health, and they say the words little to no evidence that it would endanger public safety, and I would submit that there's no evidence that this would endanger public safety, not just little evidence. But even if there was little evidence, the minister still has to grant the exemption. So we submitted all that, and that was on February 28th of 2022. In the meantime, a few more notices of intent to refuse got sent out, and we responded to those by saying, well, apply these same submissions to these new people. So in total, there were 96 healthcare practitioners that had these submissions made on their behalf. And then we waited, and we waited, and we waited. And about 100 days after that, in June 10th, I believe, all of these people were given their final refusals. And it essentially said nothing new. It didn't really respond to any of the arguments. It mentioned that these arguments were made. I'll qualify that. It mentioned that the arguments were made that an experimental trial would not be sufficient because of delay, because it wouldn't meet the training needs. But there's not a single mention of the charter anywhere in that decision. There's no, the minister, or in this case it was actually signed off by a minister's delegate, someone in the department, did not turn their mind or provide any indication that they thought about the impact of the charter. And so because of that, we got these decisions. We filed an application for judicial review at federal court. Now, very much like with Nathan's, it's the same sort of process. It's the same technical procedure, but we're asking for a different remedy here. Typically, when you have a decision and you're doing a judicial review of that decision, you ask the court to overturn the decision and have it sent back to the decision maker to redetermine it. It's because the courts understand that the legislator has delegated the authority to the decision maker, and it's ultimately their decision. The courts will just intervene to overturn it and send it back. But in rare cases where there's a need for it, where perhaps the outcome is inevitable, so there's no use to send it back to the decision maker because there's only one decision that could be made, or where there's concerns about delay or fairness to the parties, then the court will step in and say, okay, I'm making this decision for you because there's no other reasonable decision that could be made, and they will make the decision. So in our court case here, we're asking for this more rare remedy that the court would actually direct that the minister must grant the exemptions, but in the alternative, if not, then the court would just send it back to the minister to redecide with the court's reasons in mind and actually do the decision properly. Now, there's a lot of different arguments we'll be making at court on this. There's sort of two sides to the arguments. One is the standard judicial review arguments, because any administrative decision, even if it doesn't involve charter issues, needs to be reasonable. And reasonable means a number of things, but the Supreme Court has laid out a few things that involves, such as you must respond to the key arguments made by somebody who puts forward submissions. And so, as I've mentioned, there was no response to many of our key arguments. It was just, we sent it out there and heard nothing back. Also, a decision is unreasonable where evidence is misapprehended or completely ignored, or where decisions are made without any sort of evidence underlying them. And so we'll say that some of that happened in the decisions. The decisions aren't completely transparent in what they're saying in some regards, and that's another issue as well. Decisions have to be transparent. You have to actually understand what they're getting at. And there are some paragraphs in the decisions that kind of talk about the need for experiential training, but don't really say what they're trying to say. They sort of mention that some people have treated patients without first having experiential training, but then don't really draw any conclusion from that. And maybe you can see the issue there is that, well, of course, someone might be able to treat a patient without the healthcare practitioner having experiential training, but does that mean that the patient's getting the highest quality of care or the safest care. And so if you completely ignore that aspect and don't say what you're trying to say, it is the government trying to say you don't need experiential training to provide the highest level of care, to provide safe and effective care, or are they just saying you don't need it to provide any sort of care, in which case that's two different statements and requires two different levels of evidence. And then I'll just mention one final ground of review, which is the fact that the decisions go counter to the prior decisions. They granted 19 of these exemptions, and now they're allowed to do that. They're allowed to make they don't have to make every decision be the same as the past one, but whenever they do, the Supreme Court has been very clear, you must justify that departure. And there is no justification. The only justification possibly given is the experimental trials are available, except they really aren't. And some comments about experiential training not necessarily being needed, which there's no new evidence on that was different from before. So we'll be making those arguments as well as arguments that the charter wasn't addressed whatsoever, which definitely should have been.
Well, and that's a really good point, this no justification of departure. I mean, our organization tried very, very hard back in 2020 to help these 19 healthcare practitioners get access to psilocybin for training purposes. And a lot of it was, when there's a lack of available data, research materials, who are the people that a government should go to and ask for advice? It's the experts in the field. And that's exactly who we supported, was experts like Tony Bossis, Bill Richards, MAPS USA and MAPS Canada, people who have been doing a ton of research in psychedelics, and they all supported these healthcare practitioners, and as did many other doctors, therapists, and healthcare clinicians. So there has been very, very little consultation with the practitioners who are requesting this, who really are the experts, and the fact that they would depart from something that I thought that there's no way they can say no now. How are they going to make two classes of healthcare practitioners? To see that is not surprising, because they've done the same thing with many patients, but it's certainly disappointing. And this is something that for a long time we've asserted, that there's, just because a clinical trial might become available, that it's completely unethical, and also for many people will be impossible to access. Another example I've heard from one of the trials going on right now is that if you've ever done SSRIs, that you do not qualify for the clinical trial, and that's what clinical trials are like. So over and over, Health Canada has told not only the healthcare practitioners but patients, that you've got to go do clinical trials. That's the best way, and it's especially distressing for the patients who have months left to live and know that they will not qualify and probably won't have time for a clinical trial. But in the process of the healthcare practitioners, I mean, surely Health Canada must have known that a clinical trial wouldn't be possible for these healthcare practitioners, if not on the basis of the right numbers and being able to do it in the right amount of time. But you were also mentioning from an ethical standpoint, I mean, ethically, is it right to ask them to do that? And then wouldn't there also be problems with Health Canada asking a company who wants to do this to do a clinical trial? Wouldn't there be a bit of a bias there that would just right away nullify the clinical trial?
Yeah, so and this is actually exactly what you're saying, is what the internal documents that we have just recently discovered from the government do say themselves. So, we filed this back in July, and the government delayed. They were supposed to have released the documents underlying the decision within 30 days. They didn't. They brought some preliminary motions and case conferences and all of this stuff. And so eventually, just a couple of weeks ago, we got the documents underlying the decisions. And two of those documents are emails summarizing consultations Health Canada had with various other departments. And one of those was the Office of Clinical Trials. And in that email, the summary of the conversation, apparently the Office of Clinical Trials said, well, one statement was it would be impossible for TheraPsil to do a clinical trial. So there you have it from the Office of Clinical Trials. But there was all these different concerns raised, such as, well, if it's, say, TheraPsil running the clinical trial and they're practitioners and they have this sort of vested interest in it working out, doesn't that create biases? So you couldn't run a clinical trial in that way. It just wouldn't be according to proper standards. So there were a lot of ethical concerns here with a clinical trial, and this isn't TheraPsil just telling the government we can't do one. This is the Canadian government's Office of Clinical Trials saying it would be impossible.
So I just want to make sure that those listening understand this and get this straight, because for me, those internal documents are more or less the smoking gun here for the case. I mean, again, I really want to make it clear that for the last really like 2 years, every single response that we've got, almost to a standard robotic tone, has been the only available route for you is to try clinical trials. And this is after making up, as you're saying, many, many reasons why clinical trials will not work, both for the patients and for the healthcare practitioners. And am I correct in hearing you say that what we're getting is that internally, Health Canada, even those officials who have been telling us, knew the whole time that clinical trials would not be possible?
That's what this document is saying. Now, what I expect they'll argue is that, this email was, I believe, from 2019. And so I expect that they will argue that in the meantime, the fact that ATMA was approved for a trial somehow meant that they don't have to follow this advice from the Office of Clinical Trials, and you'll see it even in their wording. They never come out and say TheraPsil can do a clinical trial. It's always this very precise wording of the fact that the ATMA trial was approved means that the clinical trial pathway might be a pathway by which practitioners could gain access. So it's like this very narrow language and not even really saying much. It's just saying it shows that there is this theoretical possibility. But we know from, there's the case back in 1999, R.V. Parker, that essentially legalized medical marijuana. And in that case, the words of the court were that Section 56 is not reasonable access because it's just illusory, is what they called it. And that's exactly what this is here. The clinical trials, it's completely theoretical and illusory. It doesn't even seem like Health Canada is saying TheraPsil can do a clinical trial or these practitioners can do a clinical trial, just that there's this specter of an open pathway that could possibly exist, even though the office has said no, in this concrete case, it does not work.
Wow, that's incredible. I would maybe like you to quickly also touch upon, I know that you're somewhat involved in a case, another case of 8 clients that we're supporting in their constitutional challenge. Do you think you could just re-highlight on the constitutionality of this decision of people's Section 7 rights and maybe tie it into what's being requested from Thomas Hardle and 7 other plaintiffs on the constitutional challenge, maybe not much larger, but a very different challenge that's taking place?
Yeah, so that one is, I would say it's much larger. It's much broader in scope. Instead of just focusing on healthcare practitioners and them having access, it's saying this whole system just doesn't work. Whether it's to do with the supply side or patient access or healthcare practitioner access, all of that just needs a large overhaul to make it constitutionally compliant. And so, one of the plaintiffs in that case, Jane Harrison, is one of the applicants in this judicial review, is a healthcare practitioner who wants training and needs it to treat patients. And so these intersect in that way. And in this case, the healthcare practitioner judicial review, we're looking specifically at just these decisions, but in the charter action, so that one's an action, which is just sort of a larger procedure for a court case. It looks at everything more holistically. And one of the things that might be looked at in that case as well is, even if, let's say, Nathan got access through the Section 56 exemption, and perhaps maybe by January, February, March, sometime of this year, perhaps the court will have ordered the Minister of Health to render to give these exemptions to the healthcare practitioners. And so, maybe the government will be arguing that, well, look, they're getting access through these mechanisms through Section 56. But what that charter action will look at as well, is that a reasonable way of access for everyone to get access to psilocybin, is they have to bring a very expensive and long court case before they can finally get access. And we would submit that that's not, you can't have every individual taking the government to court just to get access. They need to go to their doctor, have their doctor prescribe it, or whatever other means specifically would work there for the doctor to be the one making the choice along with the patient, and then letting them have access once that has been approved there, not going through government bureaucrats and not having to fight them for months and months.
Thank you. And so what do you think what do you think the likelihood of this judicial review succeeding is, and what do you think the repercussions will be for the government and for healthcare practitioners and patients who are looking to access psilocybin?
I think it's very high. It's pretty clear cut. Just to mention one of the issues, we made charter arguments. The government didn't mention the charter anywhere in the decision or in any of the underlying documents. That on its own would be sufficient to have the decision sent back for redecision. That's just clear cut. That's not allowed. It needs to be redecided. Now, that would just have it sent back for redecision. So the question is, well, is a certain outcome inevitable? And we have a whole host of case law on this, specifically the PHS case, which was the Insight Safe injection site in Vancouver, where the minister didn't grant Section 56 exemption for that. And as I mentioned before, the court said, well, if you don't have evidence of harm and there is evidence of benefit to health and public safety or if there's a benefit to health and there's no evidence of harm, well, you have to. It would be unreasonable for you not to grant it. And so there you go. It's hard to see how that's not the case here. We have the record. The record demonstrates no danger to public safety, no harm to people's health, and it demonstrates a whole lot of potential positive benefits to health. And so it would necessarily be arbitrary, just an arbitrary decision to say we can't grant these exemptions when the point of the Controlled Drugs and Substances Act, the goal of it is health and public safety. And this decision just does not help meet that goal whatsoever. So I'm very confident that the court will see that and grant a directed verdict and say the minister has to grant these exemptions.
That's amazing. And then what do you think that means for future practitioners who wish to get Section 56 access for training?
Yeah, so if we win this case, it'll depend exactly how we win this case and what the court says, but it will definitely set a precedent. I believe it will be the first precedent on psilocybin specifically, although it's well in line with all the cannabis cases. So it really isn't breaking a lot of new ground legally, but it would be putting that notice out there that this applies for psilocybin as well. And it should mean that if a directed verdict is granted in this case, then the minister won't really have any way to refuse future requests by healthcare practitioners. Now, I'll qualify that a bit. I don't know what future circumstances will arise or if they will open up a genuinely accessible pathway other than Section 56 for healthcare practitioners. Because if they did, if they made it some other pathway open up that was actually accessible, then perhaps they wouldn't have to grant Section 56 exemptions. But if all things stay the same as they are now and the court rules in our favor, then it would be very hard for the minister to refuse exemption requests in the future.
That's amazing. And is there anything else you can tell me about the work that you're doing, or anything else that you want to add about either this case, the Charter Challenge, the last case, just before we time up here?
I think just the one final thing I'd mention is I've had the privilege to talk to a lot of the patients in these cases, and like I said, there was 13 of them who submitted affidavits, and I think that was very brave of them and very admirable to open up their life for public scrutiny, because all of these are public court documents, and to talk about their struggles, to talk about just the pain that they've gone through and still go through and suffer without necessarily any certainty of personal benefit to themselves too. And so I'm just very thankful to them, and I hope that the Minister and Health Canada can see them as humans and see them as people who are suffering, and not just let their bureaucratic red tape get in the way of helping real people. And so far, Health Canada hasn't seen that, I suppose, but I am hopeful then that a judge of the federal court will see that.
I'll definitely agree with you on that, and say that that's probably always been the strength of what we've been doing here. Is these are real people, right? These aren't theoretical cases. These are individual patients and healthcare practitioners who, are being mistreated, and who are being ignored for sometimes very urgent matters that are life and death, and if not life and death, are certainly causing a great deal of unnecessary suffering. So absolutely, and I want to thank you as well for all the work that you've done with TheraPsil, much of it pro bono. You've been an absolute wonder to work with, and I think a lot of people, owe you an applaud for the work that you're doing and will likely continue to do. So thank you very much.
Thanks, Spencer.
All right, nice talking with you today.
You too.